Hello everyone, this is Tom Fox and I'd like to welcome you to episode 110 of the FCPA Compliance and Ethics Report. Today I have Jonathan Armstrong, a partner in Cordair in the United Kingdom. He's going to visit with us about his new firm, his type of work, the investment made by LexisNexis in his firm under the new UK regulations allowing this, and what he sees as some of the trends for compliance going forward. The episode is about 23 minutes. I hope you enjoy it. Thank you. Hello, everyone. This is Tom Fox. I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report. Today, I'm particularly thrilled to have with me Jonathan Armstrong from the United Kingdom. Hello, Jonathan.
Hi, Tom.
Jonathan and I were virtual colleagues for many years and finally had the opportunity to meet in September at the SCCE Compliance and Ethics Institute in Chicago. I knew Jonathan as a big law lawyer from London, and he told me in Chicago that that had actually changed. And so he is now at a new firm, and I wanted to visit with him about his practice, about his new firm, about some of his thoughts on cross-Atlantic practice that you seem to do probably as well as anyone I know. So Jonathan, with that, thanks a lot, and could you tell the folks where you were and where you are now?
Yes, thanks, Tom. And great to speak with you as well. I was at Eversheds, and then I was at a big European firm, and then at Duane Morris, a big US HQ'd firm. And as you rightly say, in March, we, myself and a number of former colleagues left and formed a Cordery, and we're licensed by the Solicitors Regulation Authority here in the UK to provide advice, and we focus on compliance and technology work. So the new regime enables you to take outside investment in a law firm, which we've done. There's a higher regulatory threshold, and in addition there are higher consequences on the lawyers involved. So I know that Mrs. Armstrong was pleased that I think I got 50% more personal liability as a result. But subject to those tough qualifications, then you can have an outside equity investment, more or less in the same way that DC, I think, permits, but no US state does. And in addition, we think for compliance work, it gives us a strong hand in terms of privilege and confidentiality. So some of the work that we do around security breach, around bribery and corruption, it's obviously necessary to bring people within the firm on a short-term basis, and we can make sure that they live up to the standards of confidentiality and privilege that are required to handle those matters. So we think this new structure gives us a little bit more flexibility there as well.
Jonathan, you really said a lot in that opening statement. If I could maybe break down and ask some specific questions. The first question is, what process did you or the firm or you and your partners have to go through for the regulatory regime to get qualified, certified, or be able to open Cordery?
Yeah, no, it's a very long process, and we could probably describe it for the 2 years or so it took. But in short, you have to have lawyers running the firm still. So you have to have somebody who's in charge of the legal practice and who has to be suitably qualified and recognized by the regulator. And in addition, you have to have somebody who's responsible for the finances of the firm. You also have to have individuals that are suitably qualified to be managers, so they'll still likely all times be lawyers. But in addition, in our case, we have a board that has lawyers and non-lawyers on it, and the board runs the firm. And the non-lawyers on the board also have to go through a similar process as if they were lawyers. So things like criminal record checks, making sure that they're fit and proper people. And the shareholders, in addition, have to go through similar tests. So in our case, the directors of the company that invests in us and all the way up their corporate chain also had to satisfy fit and proper tests as well. So it's quite an onerous regime. And there are other things that apply as well. The mandatory insurance limit is higher. The liability on people if they get it wrong is higher. So there are almost flaming hoops to jump through on the way. But we think there are real advantages for our clients as well.
And you mentioned those as well. One of the keys that you explained to me in detail, I thought in Chicago, was really the flexibility. How you can bring in not only experts on an as-needed basis, but with your investors, it gives you certain access to certain things and certain research tools that you don't perhaps you wouldn't already have, and it really allows you, as you explained it, I thought, to deliver a superior legal product. And I don't want to put words in your mouth, but would that be accurate?
Yeah, I think it would. I mean, I think the first thing to say is that a lot of practices, particularly those that are smaller but not exclusively, are finding real problems getting capital investments in the world at the moment, whatever type of legal practice they are. And we're also seeing, and I was on a New York State Bar Association committee that looked at this, we're also seeing that those that can get finance are being dictated to more and more by banks. So we know of a firm, for example, that was getting around about 20% of its fee income from real estate. And the bank said to them, actually, that figure should be 15%. And they said, well, you don't know our practice that well to tell us that it should be 15, not 20. And they say, no, we know a lot of metrics about a lot of law firms, and we don't know anything about yours in granularity, but we know that we only want to lend you money if that figure's 15%. And if it's 20%, find another banker. And in this climate, it's very difficult for a legal practice to just go and take their debt elsewhere. So the first reason that I think applies to us, but also to most other people, is, it's a general rule, isn't it, that equity is usually more reliable than funding a firm on overdraft or funding a firm on short-term borrowing.
Right.
So we've come to the conclusion, I think, from the start that we'd like an equity investor that's in it for the long term, not bank debt that's in it for the short term. And that's not to diss banks across the board, but we know empirically that a number of law firms have struggled with bank funding. But then, and so we looked at that initially, and then when we looked at who that investor should be, we looked particularly at LexisNexis because of the wealth of resources that they've got. And as you say, in areas like due diligence, we know that there's a lot of resource there in the family, if you like. And if we take that resource and wrap the usual lawyers' things of confidentiality and privilege around it, then that enables us to look at that content and provide an end-to-end service for clients. So, for example, if they say, we're about to get into bed with this corporation in Russia, do you think there's an issue? I think we can provide them with a much more valid and sound answer, looking at the, whatever the figure is, 26,000 news sources that LexisNexis monitor, taking that data, looking at it in our law firm environment, if you like, in our privileged environment, and then feeding results out. So does that answer? Another long-winded answer, but does that?
It does, and it really leads into sort of the next thing which I wanted to focus on, which is your practice. And I was introduced to you, I think, via Twitter, and in three general areas. One is your technology practice. Two is your compliance or perhaps broader risk and governance practice. And then three, it's also your, if I could call it, your transatlantic practice, where you speak and write and participate in various symposia and events, certainly with the New York Bar, but in other events in the United States as well. So first, let me give a shout out to Twitter, because I'm a huge fan of Twitter. And the thing that I appreciated about your Twitter participation was that you were about content. and you were there delivering content in 140 characters, as we all do. But it wasn't about the greater glory of Jonathan Armstrong. It was about, this is the content that you might want to consider as important to your practice. So that was really the first thing that intrigued me. But it seems to me your practice now, particularly with LexisNexis, is almost an extension of your prior legal services of technology, corporate risk governance, and compliance. And now you've really melded those all together. Would that be accurate?
It would, and thanks. And without this sounding like a love-in, I mean, I'm a great admirer of your Twitter presence as well, and that is how we came across each other. And that's definitely right. I mean, we're concentrating on the stuff we know about, and the stuff we know about is compliance, technology, and you're right, the sort of transatlantic practice and the global practice of law, and where those if you like, if it was a Venn diagram, where those circles intersect is the sweet spot of what we do. And we're a small practice, but all of us have that as our DNA, if you like. And we find that these areas of practice, especially in Europe, do intertwine. So if you have an internal investigation into some issue, almost certainly the data privacy and the technology aspects are going to be a large part of that. You're going to need to secure that big bulk of data that you're grabbing. You're going to need to have a knowledge of technology to know where to get the data from, and you're going to need to have a good compliance grounding to know what you can do with it, what you're looking for, and where the end game is, where that data is going to go. So we think this sort of intersection, if you like, of technology, global practice, and compliance is challenging at the moment, and is going to be more challenging because of European rule changes around data protection, because of the increased global nature of investigations and compliance issues, because of the increased appetite of shareholders, particularly in the US, to know that the businesses they're investing in are compliant and good businesses, and because of the increasing reach of regulators globally and their increasing cooperation. So that's why, we're not hitting upon this by accident. That's the stuff we know about, and we think that there's a big enough demand for that we can build a practice around that. And we also think that if you concentrate on that, you get a lot of metrics. And whilst we're not giving any clients any data on their on other businesses at all, we can get a sense for trends in the industry that become reassuring. So we know, for example, that there's a huge rise in whistleblower claims from China. We know that from what we see, maybe only 10% of them are valid. And whenever you get a call from a distressed chief compliance officer or general counsel at sort of 11 p.m. on a Friday night our time, that's a reassuring first call to have. It isn't indicative of the fact that there's nothing in the whistleblower claim they just received, but it's reassuring to know that other corporations are getting false claims.
Sure. And that's, I think, the kind of advice that clients would call upon for people like us who have a wide variety of clients, and we can certainly talk about general trends and talk about things that regulators are saying and doing without revealing any client confidences in any way. So absolutely.
Yeah, no, absolutely.
So one of the things that you also said, which I found interesting, was that you actually preferred having, or you enjoyed, perhaps preferred is too strong a word, but you certainly enjoyed having U.S. clients, because we tend to make decisions a little more quickly here. And we would certainly rely upon you to give us your opinion. We would consult and use that in moving a decision forward. Could you describe that process?
Yes, absolutely. I mean, I think what we call it internally is get off the fence. So what we tend to find is that traditionally a lot of European corporations will ask you to set out all of the options, and then generally, if there's an option that is, I don't take a decision at all, that's what they'll go for. And they tend to be almost driven by events sometimes. Whereas I think most US corporations will have more of a suitable relationship with their external lawyers. So they'll say, don't write me a big memo setting out the options. Maybe give me one sheet of paper with the 3 options that you think I have, and guide me through which one you would take if you were me. And I think you get a much more realistic assessment of what the risks are. You have a direct discussion about what the pros and cons of each path are. But I think from our point of view, you also get more direct feedback and you get a decision quicker. So I've had projects, with European corporations where they've maybe taken 3.5, 4 years to achieve something that a US corporation has done in 3 months, just because of that compressed timeline, if you like, that ability to make decisions quickly. And I think that's, for me, certainly more rewarding as a lawyer when you feel you're part of the decision-making process and part of the team driving the business forward.
Jonathan, one of the things that I think many American compliance practitioners are not as clear about is what are the requirements now for adequate procedures under the UK Bribery Act. And one of the things that you talked to me about in Chicago was really your work to help clients put in a compliance regime, a governance regime, a risk regime. You called it various things, but it seemed to be several areas that you really focused on, as opposed to perhaps an investigation or specifically dealing with a whistleblower claim. Do you find that UK companies have those types of questions about really what does the UK Bribery Act require, and that you can answer those for them?
I think so. I mean, I think we're also seeing a very real interest from multinational businesses of complying with the Bribery Act, partly because they think that's a gold standard, but partly because there's this intertwining, as we've said, of global businesses. If you're a US corporation but you own a UK subsidiary, that UK subsidiary is likely to be subject to the Bribery Act. If you've got one of the UK individuals from that subsidiary in the room, even if the subsidiary isn't doing the deal, then that's subject to the Bribery Act. So I think many corporations are taking the decision that they've got to comply with the Bribery Act, regardless of where their business is. As far as associated persons are concerned, then I don't think we're getting so much clarity. We've got a case going through the courts this week, which might help a little bit on some of that. But I think that what we are seeing is people worry about associated persons, not only from a legal point of view, but also from a reputational point of view as well. And I think some of the cases that we're seeing, there might not be liability on the corporation, but there's certainly a reputational taint. So I think people are looking at the whole soup to nuts, as you'd call it, I think, of third-party due diligence particularly. They're looking at how to onboard people. They're looking at how to push training through the supply chain. They're looking at rechecking them, particularly in places like Russia, where the sanctions list is expanding, and that's becoming more of a worry. They're looking at integrating, in some cases, things like training and signing up to agreements with the payment process as well, so that if a corporation fails to take next month's training, then the following month their invoices will stop getting paid as well. And I think what many corporations are trying to do, like as we all are, is to try and manage more with less. So things like processes are very important. Traffic light systems to basically check where you need to put your compliance effort, but also using technology where you can. Things like integrating into your accounts back end. You can make that into a technical process rather than a manual, which I think gives more certainty, more persuasive to a regulator, and reduces effort as well.
Jonathan, we're nearly at the end of our time, but I was wondering, are there any sort of large issues that have been on the front of your mind, or important matters that, other than what we've been able to discuss sort of in the podcast so far, anything that you're sort of alerting clients to as perhaps what you've seen as a newer coming trend?
I think there are a number of things that we're looking at, particularly, just off the top of my head, the things we've been looking at this week. Due diligence, I think, is a growing trend, but also particularly challenging in Europe. At the beginning of December, we have new rules which will make it harder to background check and vet employees. So we've got this trend of you must do more about due diligence, but also this trend of you must be less invasive in the due diligence you do on individuals. And those two things don't match, particularly, as I say, with issues like Russian sanctions, and particularly because of the right to be forgotten judgment in Europe, making it tougher to look at people's backgrounds. So we're seeing those as two trends that are hitting each other like meteors, really. One of them is going to have to give, and whichever one gives, we know it's going to be ugly in terms of splinters and collaterals out there in space. So that's certainly a trend. We're seeing issues around transparency. You know, as you might know, there's some new transparency rules in the UK, which I think are a pioneer for most of the rest of Europe, Canada, I know US with Dodd-Frank as well. So looking at the extractive industries, and I think we'll see more trends there with particular industries being singled out for specific behaviour. You know, this month in the UK, it's forestry, oil and gas. But I think we can all think of another 10 industries that type of approach will be brought into. So I think we're going to look at granular regulation. And I think the other piece is a bit of a wider piece, but it's around the spread of information. The difficulty is that none of us know where our information is anytime soon. So whistleblowers, for example, are getting much more access to information than ever before to look at wrongdoing. And some of it they're making up. Because they've got so many pieces of data, you can put a persuasive story together with a fact that you can verify, plus a fact that you can verify, plus a fact that you can verify, and 8 that have been made up. And those 11 facts together are often enough to persuade a regulator that there's an issue. So I think we're seeing false claims spread, but also we're seeing corporations truly not possess their data anymore. They don't know what they own, and they don't know where it is, and they don't know how to protect it. And the difficulty is the attack team, whether that be a nation state, whether that be a business rival, whether it be an aggrieved employee or a whistleblower, the attack team get better by the day. And the defense team have limited resources and an inability to stop the invaders, if you like. So I think there, if you like, 3 trends off the top of my head that are really challenging. It is a challenging environment out there, and these threats keep evolving.
Well, Jonathan, I hope we get to do this recording again, and what I'm going to do next time is ask you start off for the trends and then explore those, because those would be great areas that we could just visit about for probably a podcast each. But unfortunately, we're at the end of our time. I was wondering if anyone wants to get in touch with you about any of your comments. Could they reach you via email?
Yeah, sure, yeah. So I'm Jonathan.Armstrong at corporatecompliance.com or Twitter at ArmstrongJP. Always happy to hear from people.
All right, well, thank you very much, and look forward to continuing the conversation.
My pleasure. Thanks for that.